Hello everyone, this is Dr.P.Syamala from the Department of MBA, IB, Acharya Nagarjuna University. And today's topic is regarding shareholders or stockholders' rights and remedies. Okay, so what are the rights and what are the remedies of shareholders or else stockholders? Okay, both shareholders or stockholders both are the same. So before going to study about the rights of a stockholder or a shareholder, we'll know about what is a share, who is a shareholder, what are the types of shareholder, and then we'll see the rights of shareholders or stockholders. So if we see in India, companies are mostly established and governed by Companies Act 2013. Okay, so we all know all the legal aspects, or else from incorporation of a company to winding up of a company. In each and every aspect, they have to follow the Companies Act 2013. So there are basically two types of companies established in India. We all know, in previous classes also we have learned about the forms of business or else the types of business organizations, which are nothing but majorly public limited company and private limited company. In India, people prefer to open private limited firms because of fewer restrictions and more benefits, okay, rather than public limited company. And shareholders play an important role in a company. We all know that shareholders are the owners of the company, and it is very important for a company to look after them, as they should also be safeguarded. Okay, the interest of the shareholders should be safeguarded, and they receive dividends. In the form of dividends, they will receive the income, okay, on their investment in the company in the form of shares. So what are shares? Shares are nothing but the shares are the stock certificate. Okay, shares are the stock purchased by shareholders in a company. Okay, for that a stock certificate will be given to the shareholder, which is nothing but ownership certificate. Okay, so those are known as shares or shares of stock in a given company. So a person, a company or organization owns a share or shares of stock in a given company. So who is a shareholder? Means a shareholder, commonly referred to as a stockholder. Either shareholder or stockholder is any person, company or institution that owns at least one share of a company's stock. Okay, so because shareholders are company's owners, they reap the benefits of the company's success in the form of increased stock valuation. Okay, if at all the company, as they invested their money or else invested their capital in the form of shares in the company, if at all the company is going in a positive side, which is nothing but profits are being seen by that company, means definitely these shareholders are going to reap the benefits of the company's success in the form of increased stock valuation. Their stock value, their share value will be increased. For example, they have purchased a share for 100 rupees. If the company is going in a profit side, the share value may be increased to 400 rupees or 200 rupees. Likewise, means their value is increased, the share value is increased. So shareholders play an important role in the framing and profits of the company. Shareholders are the owners of the company, as we all know from the previous class, I'm saying shareholders are the owners of the company. They are the main stakeholders in the company. We have studied two types of stakeholders as primary stakeholders and secondary stakeholders. Primary stakeholders are nothing but these shareholders, employers, okay, customers, suppliers. All these will be the within the internal management persons associated with the company, which are who are known as primary, okay, stakeholders. And coming to secondary stakeholders, they are outside the associated with the outside of the organization. For example, government, okay, competitors. So likewise, all those are considered as external organizational factors, okay. So they are considered as secondary stakeholders. So now these are the primary stakeholders who are very, very important for the organization and also main stakeholders and owners of the company. So the ownership, okay, see, as I said, if the company is in a success position, definitely shareholders reap the benefits of the profits of the company. For example, if the company is in a liquidation, okay, or else insolvent, okay, then what happens? Initially assets will be sold out, okay, and they are not obliged to shoulder the debts and financial obligations incurred by the company, okay. So no way these shareholders are responsible for the company's liquidation, okay. But to what extent they incur losses means to the extent they have invested in the company. For example, a shareholder invested 10,000 shares in a company undergoes liquidation, okay. Then what happens? He doesn't pay any amount. He is not responsible to pay from his personal assets, but the 10,000 rupees will be lost to that particular shareholder, okay. So the ownership of shareholders is represented by common or preferred shares. Common shares or equity shares and or preferred shares, okay. So issued by the company and held by the shareholder. So ownership of a shareholder by investing in the company, how the shareholder is treated, how the ownership is given to the shareholder means it is the ownership is represented by equity shares or else preferential shares, okay. Depending upon this, the income or the dividend will be paid to the shareholder. Now coming to types of shareholders, okay. There are three types of shareholders, okay. Equity shareholders, preferential shareholders and debenture holders. So equity shareholders means equity shareholders or common shareholders are the main stakeholders in a company, and when the time of dividend distribution comes, preferential shareholders would get the first, okay, even though they are primary owners of the company, okay, who will receive their dividends first. When the time comes to distribute them, when the time comes to distribute them means at times of insolvency, okay, at that time who will be given first preference to settle their accounts means first preferential shareholders will be given preference. Their account will be first settled down. After that only, if at all any amount is there, then that amount will be given to these equity shareholders. If there is no amount after giving preferential shareholders means there will be no amount for equity shareholders, okay. So you can say that equity shareholders are the primary owners of the company, and equity shareholders refers to the owner's claim on the assets of a company after debts have been settled. Okay, after debts have been settled means after preferential shareholders have been settled, then the amount will be given to the equity shareholders in case of insolvency. If at all the company is going on well, everything is good, the company is seeing profits, then these are the first persons, primary owners, who will receive their dividends first. Okay, and the how can we calculate equity shareholder or else shareholders equity means by taking the company's total assets, okay, minus the total liabilities. Okay, we have to less liabilities from the assets of the company. Okay, then only the remaining amount will be given to the shareholders, which is known as shareholders equity. Okay, means the company did with its capital investments and profits earned during the period. Okay, means from the expenses, okay, revenues minus expenses, the profit will be there. From that, the amount will be given to these shareholders. Okay, and the shareholders equity can either be negative or positive, as I said before. Okay, so here a negative shareholder equity means shareholders will have nothing left when assets are liquidated and used to pay all the debts owed. Okay, on the other hand, positive shareholder equity means company's assets have grown to exceed the total liabilities, means our assets will be more than our liabilities, then it is treated as a positive shareholder equity, meaning that the company has enough assets to meet any liabilities that may arise. But investors are wary of companies with negative shareholder equity. They are reluctant towards the companies because of this negative shareholder equity, since such companies are considered risky to invest in. Okay, and shareholders may not get a return on their investment if the condition persists. For example, if assets are liquidated in a negative shareholder equity situation, all assets will be insufficient to pay all of the debt and shareholders walk away with nothing. Okay, shareholders equity can help to compare the total amount invested in the company versus the returns generated by the company during a specific period. So how can we treat shareholders equity means assets minus liabilities. If assets are more means definitely shareholders equity is in positive side. Okay, so when calculating shareholders equity, all the information needed is available on the balance sheet on the assets and liabilities side. The total assets value is calculated by finding the sum of current and non-current assets. Okay, so current assets means which are nothing but easily which can be quickly converted into cash. Okay, and liabilities are the total current liabilities or else the short-term liabilities and long-term liabilities comprises of debts, okay, which the company has to pay, required to pay. Okay, those are liabilities. So this is about the shareholders equity. Okay, and coming to preferential shareholders. So who are preferential shareholders means generally preferential shareholders, they have no voting rights because of their preferred status. Okay, they are preferred, they are a special. Okay, so they receive fixed dividends generally larger than those paid to common stakeholders. Okay, that is why we call them as preferential shareholders or the persons who are having the preferred status. Okay, they receive more than income than these equity shareholders. Okay, they may receive fixed dividends, okay, or else they may receive certain percentage on the par value of the shares. Okay, likewise on different ways they will receive depending upon the articles of incorporation, depending upon the articles of incorporation of that particular company. The company decides how to pay, on what basis they have to pay. Okay, so depending upon that, these preferential shareholders will be given dividend. Okay, either fixed dividends or else the percentage on the par value, and their dividends are paid before common shareholders. Means at the time of insolvency, for example, if the company undergoes insolvency, means first these are the persons who will get their amount, then only after paying to these preferential shareholders only equity shareholders will be paid. Okay, so the number of shareholders in a company depends upon the type of company which they are opening. Like for a one-person company, one person is required. For a private limited company, 2 persons are needed. For a public limited company, a minimum of 7 persons are required. Okay, so likewise it depends upon the type of the company also. Okay, the minimum numbers or the minimum number of persons required for this type of companies. Okay, like 1-person company, private limited company, and a public limited company. So if we see debenture holders, okay, so debenture holders are not owners, okay, but creditors of the company. Okay, instead of dividends they receive interest. Okay, here if we see equity shareholders and preferential shareholders, they will receive profits in the form of dividends. But coming to debenture holders, okay, they are not treated as shareholders but treated as creditors. They are not treated as owners, they are treated as creditors, and at the same time they will receive profit in the terms of interest but not in the form of dividends. Okay, so these are the types of shareholders. Okay, now if we see rights of shareholders, so what are the rights of shareholders? Broadly they are divided into 3 types. Okay, rights. First rights of shareholder is individual shareholder, rights of individual shareholder, rights of minority shareholders, and rights of majority shareholders. Okay, individual shareholder means the person who individually responsible to the company and the company responsible to that particular individual who purchased shares from that company. Coming to minority shareholders, what are minority shareholders? Who are minority shareholders means minority shareholders are those who have invested their money in the company but they are not holding so many shares that can give them controlling powers. Okay, and because of this their interest in the company and its affairs sometimes get neglected. Why? Because they are the minor shareholders. Majority of shareholders will have major number of shares, more number of shares compared to minority shareholders. So minority shareholders means the persons who have invested their money in the company but they are not holding so many shares. Okay, and we can say that minority shareholder refers to an individual or an entity that holds a minority or less than a controlling interest in a company, where we can say that he owns a portion of the company's shares that is smaller than 50%. Okay, and they do not have the power to control or influence major decisions within the company on their own. So they do not hold a majority of shares. Minority shareholders have limited voting power in corporate decisions, and they may not be able to sway the outcome of major resolutions or appointments without the support of other shareholders. So those are the minority shareholders. And coming to rights of shareholders, okay. So generally, what will be the rights of shareholders? Means these rights of shareholders can be entrusted to these majority shareholders and these individual shareholders. Okay, so all this comes under the individual shareholder or majority shareholders. And coming to first right of shareholder means appointment of director. So appointment of director means a significant influence on the appointment of directors is exercised by shareholders. We all knew that in business structure or corporate structure, we will see shareholders appoints the directors, okay, and directors form board of directors and they will appoint the C executives, and those C executives appoint the president, vice president, okay, vice presidents of different departments of the company, and managers, supervisors and workmen. Okay, this is the business structure or else the corporate structure in a company. Okay, so appointment of director starts from shareholder. So shareholder as a owner of the company, he will appoint the directors, okay, and board of directors will be formed. So the appointment requires the shareholders to pass an ordinary resolution. In addition, a shareholder may contest any resolution that the general body meeting passes appointing a director. Okay, in appointment of director, we will see shareholders appoints the directors, and for that it requires passing an ordinary resolution in the annual general body meeting. Okay, so shareholders play an important role in the appointment of directors. An ordinary resolution is required to be passed by the shareholders for the appointment, and apart from this, shareholders can also appoint various types of directors, like an additional director who will hold the office until the next general body meeting. Okay, at the same time, an alternate director who will act as an alternate director for a period of 3 months, and a nominee director, and also director appointed in the case of a casual vacancy in the office of any director appointed in a general meeting in a public company. Okay, apart from these, shareholder also can challenge any resolution passed for the appointment of a director in the general body meeting. Means challenging means if at all the shareholders doesn't want that particular director, means through resolution, okay, they can change the directors. Okay, so these are the rights of shareholders in appointing a director. And if we see legal action against directors, okay, so legal action against directors means, according to the Companies Act 2013, according to that, legal actions can be bring against directors by the shareholders, okay, according to the rules laid down in the Companies Act 2013. So what are those legal actions against director means any action taken by director that negatively impacts the company's operations in any way. Okay, which means any act done by the director in any manner which is prejudicial against the affairs of the company, and any action which is against law or constitution. Okay, law or constitution, and which is against fraud, company assets are being transferred at a discount to their market value. Okay, it means that undervalued rate, even though the market value is, for example, for share 500 rupees. Okay, even though there is 500 rupees per share in the market value, if they have transferred at a discounted price, for example 500 share value means if they sold out shares in a discounted manner means for rupees 300. Okay, so in that case also these shareholders can take legal action against the directors of the company. So in case where the shares are transferred at an undervalued rate, and when the company's finances are diverged, means there is a diversion of funds of the company. So any action carried out dishonestly means act done in a malefied manner, means dishonest can be referred to as malpractices done by the directors in a company. So these are the legal actions that can be taken by the shareholders on directors of a company. And coming to another one, appointment of company's auditor. So appointment of company's auditor means shareholders also have a right to appoint company's auditors. Under Companies Act 2013, the first auditor of the company is to be appointed by the Board of Directors, BOD. Okay. Further, the shareholders are at the annual general body meetings at the recommendation of directors and audit committee. The appointment is generally here done for 5 years and further can be ratified by passing a resolution in the annual general meeting. Okay. So appointment of company auditors can be done with the recommendations of directors and audit committee, but initially appointed by the first auditor of the company will be appointed by the board of directors. Okay, then the audit committee, here see audit committee and directors. Okay, according to their recommendations, the shareholders appoints the company's auditor. Okay, and also appointment is typically valid for 5 years and also it can be extended. How can it be extended? Means by passing a resolution in the annual general meeting, which is known as AGM. Okay, and voting rights. So what does voting rights means? Shareholders are typically involved in making crucial decisions. We all know that as the owners of the company, okay, they are also involved in the decisions, means by attending the meetings of a company, okay, by taking part in the meetings. So they are also involved in making crucial decisions in the company through their voting rights. Okay, so how can they involve in the company's decisions? Means through voting rights only. So shareholders also have the right to attend and vote at the annual general body meeting. Every company registered in India should comply with the provisions of Companies Act 2013. Why? Because all these legalities, legal aspects are connected with the Companies Act only. So from the incorporation of a company to the winding up of a company, each and every stage, at each and every stage, it has to act according to the provisions of Companies Act 2013. It is mandatory for every Indian company to hold an annual general meeting, AGM, once in every year. Okay, so the meeting can be held anywhere at the head office of the company or any other places as given by the company. Okay, so at the meetings there are various mandatory agendas which are to be discussed. These include the adoption of financial statements, appointment or ratification of directors and auditors, etc. So in voting, at the time of voting, what things may happen, or else in what cases these shareholders will be involved, means many aspects in financial decisions, okay, in appointments, in ratification of directors, in auditors appointment with recommendation of directors, in many things, okay, by passing a resolution, okay, and by means of voting, the shareholders will elect these directors and at the same time involve in the decisions of the company, okay. So if we see in voting rights, we will see two main aspects. One is annual elections and the other one is the fundamental changes, okay. So annual elections means shareholders typically vote annually to elect or remove members of the company's board of directors, okay. So in such case, in annual elections, voting rights will be availed by the shareholders. Why? Because to elect or to remove the members of the company's board of directors. If we see another aspect, fundamental changes. In this case also voting rights are used by the shareholders. Why? Because they also vote on major corporate changes such as dissolving the company. Okay, in that aspect also, that is fundamental changes of a company. In that major decisions also, shareholders use their voting rights. Okay, so general rule for voting is naturally one share, one vote. Okay, here one share, one vote. This is standard unless the company's articles of incorporation specify a different arrangement. Okay, basically the general rule for this voting is one share means one vote only, but in some cases, okay, depending upon the articles of incorporation of that particular company. We all know articles of incorporation means which deals with the internal affairs of the company, okay. So it fully depends upon the policies and procedures of that particular company. So in that, the company may specify how would be the vote, okay. So like when a company allows for cumulative voting, okay, cumulative voting. So what does cumulative voting means? Each share gets as many votes as there are director positions to fill, okay. So that is known as cumulative voting, okay. So it allows, cumulating voting means it allows many votes, okay. Shareholders can distribute these votes in any manner, including putting all votes on one candidate also, okay. Why? Because in this system, in cumulative voting, each share gets many votes as there are director positions to fill, okay. Means if there are 5 directors, means that one person who is having one share can decide on those 5 directors also, means 5 times he can vote. So that is known as cumulative voting. So this method is particularly beneficial for minority shareholders. Why? Because minority shareholders have very less shares compared to the majority shareholders, okay, and their representation is also less compared to majority shareholders. So that is why in that case it will be good, okay. So for example, 5 director positions are available, okay. Minority shareholder owns 100 shares. So in cumulative voting system, each share equals to 5 votes, okay. Each share equals to 5 votes. For example, 100 shares, okay. Each share 5 votes. Because of 5 directors, 5 votes. So totally how many votes would that shareholder gets? Means 500 votes, okay. 500 votes. means 100 shares into 5 votes is equal to 500 votes. Okay. So voting distribution will be, they can allocate all 500 votes to one candidate for greater influence. Okay. So this approach enhances the chances of shareholders' preferred candidate being elected. Okay. So this is regarding cumulative voting. Okay. Or else generally the rule will be one share, one vote. But in some cases, depending upon the company's articles of incorporation, the company may allow cumulative voting, which is nothing but each share gets as many votes as there are director positions to fill. Okay. So voting rights consist of approving the financial statements, designating or validating the directors and auditors, among other things. So this is about the voting rights of voting for shareholders. Okay. Right to call for meetings. So shareholders have the right to call a general meeting. They have a right to direct the directors of company to call for extraordinary general meeting. They also can approach the company law board for the conduction of general body meeting if it is not done according to the statutory requirements. If at all the company members they are not conducting the annual general meetings means, okay, at that time these shareholders, they can approach the company law board for conducting that annual general body meeting. Okay, according to the statutory requirements, if they are not performing means they can approach the company law board. Okay. Next, right to inspect registers and books, or else the records and books. The right of shareholder to inspect a corporation's books and records is an important aspect of corporate governance and transparency. Okay. So written notice requirement. Okay. So when these shareholders want to inspect the records and books of a company, okay, so they have to first written notice requirement should be given. Okay. So if at all a shareholder wishes to inspect the corporation's records, they must provide at least 5 days written notice that they want to inspect the records and books. Okay. And proper purpose. Okay. So what does proper purpose means? The notice must state a proper purpose. Okay. So this means the reason for inspection should be related to the shareholders' interest in the corporation. So first of all, a notice is required by the shareholder to the company. Okay. So what is in how many days? At least before 5 days a written notice should be sent that they are going to inspect the registers, records and books. After that, in that notice what should they have to fill means the notice should be a proper purpose. Okay. So a reason for inspection should be mentioned there. And coming to representation, under representation, shareholders are permitted to send a representative such as attorney, accountant or any other agent to conduct the inspection on their behalf. Because for example 100 shareholders are there in a company, or else 1000 shareholders are there in the company. All the shareholders, they cannot come and see. So they will permit to send a representative such as attorney, accountant or any other agent to conduct the inspection on their behalf. Okay. So next, if we see proper versus improper purposes. Why? Because we have to give proper purpose. We have to mention the reason of inspection. So what is that purpose? Is it proper or else improper? So proper means to initiate a derivative suit on behalf of the corporation. It is nothing but a lawsuit on company. It comes under the proper purposes. And to solicit other shareholders for votes on corporate matters such as electing directors means we are sending another person on behalf of us. So in that cases also, for voting in electing directors, okay, in that proper purpose also we can initiate other persons. And coming to improper purposes, what are improper purposes? Means activities not related to shareholders' interest in the corporation. Okay, so why we have to inspect the company's records and the books? We have to mention the reason. So the reasons may be proper purposes and improper purposes. So if at all improper purpose means, what does it means? Means it doesn't relates to the interest of the shareholder, okay, such as obtaining names for a retail mailing list can be grounds for denying inspection. If at all it is an improper purpose means, okay, they are not, the tribunal will not allow the shareholders to inspect the company. If at all it is a proper purpose, it is on the grounds of interest of shareholders means definitely tribunal will allow the shareholders to inspect the company. But if at all it is an improper purpose means, okay, the tribunals will deny the inspection of shareholders in the company. Coming to right to get copies of financial status. So right to get copies of financial status means shareholders have the right to get copies of financial statements. It is the duty of the company to send the financial statements of the company to all its shareholders either in a quarterly or annual statement. Okay, so definitely they have to receive the company's financial status. Why? Because they have invested their money in the company. So they have to know what is going on in the company. Is the company is in a profitable position or not? Okay, and coming to winding up of the company. So winding up of the company means before the company is wound up, the company has to inform all shareholders about the same, and also all the credit has to be given to all the shareholders. So winding up of company means we are closing the company. So while closing our company, we have to the company is responsible to inform all the shareholders, okay, and also the credit that has to be given to the shareholders, the company should pay to the shareholders. It is the right of the shareholder to receive his amount which is invested by him in the company. Okay, generally winding up of companies will be done when at the time where the company is unable to perform, the company is unable to run the business. In such time, at that time only the company will go for winding up. Okay, and coming to minority shareholders. Okay, so what does minority shareholders means, and what are the rights of minority shareholders? Okay, so minority shareholders refers to an individual or entity that holds a minority or less than a controlling interest in a company. Okay, means compared to the majority shareholders, okay, the shares held by these shareholders will be very less. So that is why we call them as minority shareholders. The shares that they have are very, very low. Okay, and the portion, the company's shares that is smaller than 50%, and they do not have the powers to control or influence major decisions within the company on their own. Means minority shareholders, they don't have any voting power. Limited voting power is there in taking corporate decisions. Okay, if we see first right of minority shareholder means right to information. Okay, so right to information means access to relevant and timely information about the company's financial performance, operations and strategic plans, regular updates on major corporate developments and decisions. All these are related to the company's information. Okay, the relevant and timely information should be produced to the shareholder. Okay, definitely each and every company performs day-to-day business operations. It takes strategic plans. Okay, at the same time it will take decisions regarding the growth and expansion of the company's financial performance of the company. Okay, so each and every aspect should be circulated to the shareholder. They should have the access to relevant and timely information. Why? Because they are the owners of the company. They have invested their money in the company. And coming to second one, voting rights. So voting rights means the right to vote on important matters, including the election of directors, changes to the company's articles of incorporation, as I said before, cumulative voting rights. Okay, so it depends upon the company's articles of incorporation, or else general rule is one share, one vote. Okay, likewise changes in mergers and acquisitions, depending upon these aspects, voting rights will be given. Okay, a right to vote matters. A protection against dilution of voting power without proper notification or approval. Okay, voting rights means protecting the shareholders, okay, against dilution of voting power without proper notification is not an approval. Okay, means they cannot do dilute the companies cannot dilute the voting power of a shareholder without proper notification to the shareholder, and at the same time proper approval. Without proper approval, without proper notification, the company cannot dilute the voting power of a shareholder. So this is about the voting rights. So if we see about dividend entitlement, okay, so dividend entitlement means the right to receive a share of the company's profits in the form of dividends. Every company, if it is in a positive share, means positively the company is going on, means definitely profits will be earned. So if at all the profits are earned, means those profits will be paid to the shareholders in the form of dividends. So if declared by the board of directors, fair and equal treatment in dividend distribution should be there. So that is the right of the shareholder. According to his investment in the company, fair value should be paid to the shareholder. Equal treatment, there should not be any discrimination between the minority shareholders and majority shareholders. Fair value should be given to both the shareholders and equal treatment should be given. So dividend distribution should be made in a fair way. Okay, and we all know that no automatic right to dividends will be there. Automatically dividends will not be given. Okay, shareholders do not automatically have a right to distributions, like cash, okay, share repurchases likewise. These are only available when they are declared by the board of directors only. Okay, so once if a dividend is declared means, okay, shareholders are considered unsecured creditors of the corporation to the extent of the dividend amount in case of bankruptcy. Okay, so dividends will be paid to the shareholders, okay, when company gets profits. Okay, if at all company undergoes insolvency, okay, then what happens? First, these shareholders are considered as unsecured creditors. Why? Because they will not be paid the amount. As I said before, in equity share holders, okay, they will be paid after paying other liabilities or after paying preferential share capital. Preferential shareholders, these equity shareholders will be given. So likewise, it depends upon the dividends will depend upon the unsecured creditors, means after paying preferential shareholders, okay, then only equity shareholders can be paid. That too, these unsecured creditors are treated as unsecured to the extent of the dividend amount only. That means the invested amount only. Okay, and here if we see in dividends, decrease in equity can be seen. Okay, it means that decrease in equity means any distributions made to shareholders, it reduces the company's total shareholders equity. Okay, why? Because equity shareholders amount will not be paid, okay, as like preferential shareholders. Why? Because preferential shareholders will be paid time to time with a certain percentage or depending upon the fixed amount. Okay, but these equity shareholders are not paid immediately. The amount will not be paid immediately. So if at all in case of if we see any distributions were paid to the shareholders, that is known as the preferential shareholders, it reduces the company's total shareholders equity. Okay, so this is about the dividends. So finally we can say that dividends are nothing but the share of company's profits in form of dividends. So that too, it should be declared by the board of directors, and fair and equal treatment should be given between the minority and majority shareholders. Okay, and coming to preemptive rights. So what does preemptive rights means? Okay, so preemptive rights are the right to maintain a proportionate ownership stake in the company. Okay, preemptive means proportionate ownership stake in the company by having the first opportunity to purchase additional shares before they are offered to external parties or outside the company. Okay, so those are known as the preemptive rights. So if you allow current shareholder, for example, preemptive rights means if you allow a current shareholder the opportunity to purchase additional shares before the corporation offers them to the general public. For example, if a person is already having 10,000 shares in a company, okay, 10,000 shares. shares in a company. Okay, so if the company now want to, already the company is having 1 lakh shares, in that a person is having 10,000 shares. Okay, now the company want to raise that 1 lakh shares to, again it want to issue new shares of 40,000. Now 1 lakh shares becomes 1,40,000 shares. Okay, so whenever it is increasing about 40,000 shares, okay, whenever it is increasing this share, first it has to inform. Okay, first it has to allow the current shareholders. It should give the opportunity to current shareholders to purchase additional shares, or else newly issuing shares before going to the general public or before going to the external parties. Okay, so this right is very crucial for shareholders who wish to maintain their proportional ownership and voting strength in the corporation. Okay, why? Because as I said before, at the time, in some crucial times, the voting rights influence very much in the company. Okay, so if at all it is following any cumulative voting rights, means this means a lot. Okay, so the person already having the shares in a company, and if at all the company is going to issue new shares, means first preference should be given to the inside person, already existing person who is having shares. Okay, so on what basis those shares will be given? For example, here the person is having 10,000 shares in 1 lakh shares, means 10% of shares he is having, okay, in the company. So the newly issuing shares are 40,000. So 40,000 means on this 40,000, 10% shares have to be given to this person. 40,000, 10% means 4,000 shares should be given to this person, means altogether 10,000 plus 4,000, 14,000 shares should be given to the person. This person will possess 14,000 shares. Okay, so this is about the preemptive rights, means purchasing. Preemptive rights means purchasing the shares. Okay, already even though he is having the shares, the new shares which is the company want to issue to general public. Okay, so the company should give opportunity to the persons who is already having shares in the company, then only it should offer to the general public or external parties. So this is known as preemptive rights. And if we see the right, all preemptive rights are not automatically assumed. They must be in the articles of incorporation. We cannot assume before purchasing shares in a company that preemptive rights are there for a shareholder. Okay, so if a company is having preemptive rights, means then the person can purchase shares in that company. If at all the company does not have the preemptive rights in its articles of incorporation, means before purchasing, before investing in that company, it is the duty, it is the responsibility of the shareholder or the investor to know about the articles of incorporation. Is there preemptive right protection shareholder from dilution is there or not in the articles of incorporation or not? If at all there is no preemptive rights in the articles of incorporation, means the investors should not invest in such type of companies. Okay, why? Because it incurs loss to the investors. So the responsibility of an investor before investing in a company, he should know about preemptive rights do exist in that company or not. How it knows? Means by reading the articles of incorporation of that company. Articles of incorporation is nothing but the internal state of affairs, internal management policies and procedures of that company. Okay, if we see another aspect, right to sue. Okay, means the ability to take legal action against the company or its management for actions that may harm the interest of minority shareholders. Okay, so whenever the interest of minority shareholders, as I said before, minority shareholders are the persons who are having very less shares. So when there is a case that there is harm to the minority shareholders interest, means Okay, in order to protect on this oppressive management or unfair conduct by the majority shareholders or the management, the shareholders has the right, the ability to take legal action against the company or its management for actions. Okay, see, in this right to sue, we will have many things to read, but we will study in depth regarding this right to sue in remedies. Okay, so as far as now, right to sue means the shareholder has the every right to sue or else to take legal action against the company if at all it is the actions of the management or the company may harm the interest of the minority shareholders. Okay, so if we see about the next one, appointment of directors. Okay, so appointment of directors means uh, the ability to nominate and vote for directors, ensuring representation on the board, protection against actions that may undermine the ability of minority shareholders to have a fair say in director appointments. Okay, so ability to nominate, vote for directors. Okay, so here the board should ensure the shareholder, okay, to nominate the directors, vote for the directors, okay, in while conducting the annual general meetings. So the representation should should be given by the board of directors to the shareholders, and also protection against actions that may undermine the ability of minority shareholders to have a fair say in director appointment. Not only majority shareholders should be considered, but minority shareholders also have a limited right. Okay, so their right also should be protected. Okay, they should not undermine the ability of minority shareholders, the companies. Okay, so in appointment of directors also these minority shareholders will have the rights. And coming to exit options. Okay, so exit options means the right to sell or transfer shares at a fair market value. Exit means we are leaving the company. So leaving the company, when it happens means when we sell our shares or else when we transfer our shares. So while selling or while transferring our shares, we should sell or transfer our shares at a fair market value only. Okay, if at all the ability to exit the investment without facing any unfair restrictions should be seen. If at all there is any unfair restrictions means the shareholder can go legally. Okay, so exit options, the shareholder has the right to exit option, that too with a fair market value. Next, right to inspect the records. The right to inspect certain corporate records including financial statements, minutes of meetings and other relevant documents, each and everything, many aspects. So shareholder has the right. Okay, like corporate records, company records. What company records consist of? Basically financial statements, minutes of meetings and other relevant documents, but not the in-depth or else full documents cannot be given, but the very proper documents that the shareholders has the right to inspect, those documents will be inspected by the shareholders. So access to information that helps in understanding the company's affairs. So it is known as the right to inspect records. Okay, the shareholder has the right to access of information that helps in understanding the total company affairs. Why? Because he has invested his capital in the company, therefore he has every right to know about the company's affairs. Okay, and another one is fair treatment in mergers and acquisitions. So the right to receive fair consideration and treatment in event of mergers, acquisitions or any other significant corporate transactions. Okay. For example, if our company is going to merge, okay, so whenever it is going to merge or whenever we are taking over other company, at that time, okay, fair consideration should be given to the shareholders. Okay, so they should not, the shareholders should not undermine. Okay, so fair treatment should be given, fair payment should be made to that shareholder. And protection against transactions that may be designed to unfairly benefit majority shareholders. So many companies too, they may do favor to majority shareholders because they are having more shares, undermining the minority shareholders. In such type of transactions, protection is given by the tribunal to the shareholders. Okay, and right to share in surplus assets. Okay, right to share in surplus assets means in the event of liquidation. Okay, in the event of liquidation or else insolvency, the right to receive a share of the remaining assets after creditors have been satisfied will be satisfied. Okay, so whenever a company is insolvent, first it will be, the amounts will be paid to the preferential shareholders, okay, secured creditors. So after that, these minority and majority shareholders will be paid the amount, okay, in the event of liquidation. So they have every right to receive a share of the remaining assets after creditors have been satisfied. Okay, so these are all the rights to minority shareholders. Okay, so each and every aspect, like electing the directors, auditors, okay, or else dividends, taking of dividends, in exit options, or else inspecting the records, in winding up of the companies, in seeing the financial statements. Okay, so in different aspects, shareholders have different rights. Okay, and in next class we are going to study about the remedies of the shareholders. Okay.